Sure, and we have criminal defense attorney Elizabeth Kelley with us now. She's going to be in the courtroom watching the arguments as well. But from a criminal defense attorney standpoint, Elizabeth, thank you for being with us. Let's talk about
Good morning, Christy.
Good morning. From a legal angle, how strong is this appeal?
It's very strong for a couple of different reasons. First of all, the defense attorney argued 11 what we call assignments of error, mistakes that the trial court made that denied Dr. Issa his right to a fair trial. And secondly, many of those 11 arguments are very, very strong. Grace talked about the fact that hearsay was improperly admitted, the fact that the trial court failed to give specific instructions as to the bias and motivation of certain witnesses. And also there are some very strong arguments regarding the improper admission of character evidence, and in particular, evidence that Dr. Issa had herpes. So by no means is this a done deal for the prosecution. I expect that Steve Miles, during the course of this oral argument, will argue very, very vigorously that the verdict should be vacated and that Dr. Issa is entitled to a new trial.
Okay, so walk us through the process. What does the defense have to prove to garner this appeal, and then what happens therefore from that point on?
If the defense prevails on any one of these 11 arguments, then the Court of Appeals can vacate the conviction and send it back to the trial court for a new trial. However, as you know, in the Court of Appeals, the burden of proof is basically flipped. That is to say, in the trial court, the prosecution has the burden of proof and the defendant is presumed innocent. All of that changes upon conviction, and now the burden is on the defense.
So if you flip the burden, and this is on appeal, and he gets a new trial, how strong do you think another conviction might be?
I don't know that Dr. Issa would be convicted if the conviction were vacated and a new trial was held. I know in my own experience a couple of years ago, I had a life sentence overturned, and the Court of Appeals sent it back to the trial court. However, based on the strength of my argument, the prosecution really didn't want to retry this case, and to put it bluntly, notwithstanding my client's innocence, the prosecution made my client an offer he did not want to refuse, and they basically offered him a year in prison, and he'd already served 50 weeks.
So based on what you know about this case, Elizabeth, do you see a similar outcome in this case based on what Mr. Issa is up against if it does go back to trial?
Well, none of us know what the panel is going to do this morning. What you need to remember is that courts of appeals sometimes agree in large part with the defense. They argue that the trial court did make an error or errors. However, they come back and say, or continue to say, that notwithstanding the error, it was basically harmless error. And this Court of Appeals could very well say that Dina Calabrese, the trial court judge, did make some mistakes. However, the evidence against Dr. Issa was so voluminous, was so overwhelming, that it didn't matter.
Okay, so they can say, yes, there was a mistake, but it doesn't equate to an appeal here. How soon will it be before we understand or before we know whether an appeal could be granted?
It's been my experience that in this particular Court of Appeals, it takes about a year from the time that the trial court sentences a defendant until the time the Court of Appeals does make its decision. And I want to go back real quickly to the prior question that you asked me about harmless error. One of the things that Steve Miles did argue in his brief was that although no single error might have constituted or might have denied Dr. Issa his right to a fair trial, the accumulation of all those 11 errors denied him the right to a fair trial.
Okay, I gotcha. Elizabeth Kelley, criminal defense attorney. Thank you so much for getting us caught up on all of this. We appreciate it, Elizabeth.
All right, I'll talk to you later.
Will
Bye-bye.
do. Thanks. Bye-bye.